She said, my name is Dan Kostrub. I'm an attorney with Steptoe Johnson, work in our Canton, Ohio office. The introduction definitely sounded sexier than it actually is going to be, the Canons of Construction. It's always tough being close to the end of the day, after prizes, after a good speaker, but we'll try to muddle through as very quickly as possible. I'll tell you, as I gave an ethics presentation probably a year or so ago, and I told them I would swear to God that I talked for an hour, as long as they promised not to swear that I didn't. So we'll hold the same thing. Goes true for this presentation as well. We'll get through and get done quickly. I'd like to give a special thanks out to the folks that have done the yeoman's work on this. Being a partner, I don't actually do a lot, but don't tell my other friends, Gary. Roger Christensen, who should never have won that mug. Dominic Ranieri, who's a law student, will join us next year. James Tartaglia and Alexandria Lay did most of the work on this project. I was basically there to review and say, looks good to me. Again, I will lie if you bring that up again. A little bit of shameless plug about Steptoe and Johnson, because Mr. Steptoe likes us to do this. We've been around for 100 years. We've been doing energy work for 100 years. We have 13 offices throughout West Virginia, Pennsylvania, Ohio, Kentucky, and Texas. We have over 270 attorneys. We're the largest, have the largest energy practice in Appalachia. We're the 12th largest in the nation. And not only do we do all sorts of energy work, we handle labor employment issues, workers' comp, and all types of complex litigation. So that's for Mr. Steptoe. Can't see. The lady was right, it's very difficult to see back here. Okay, let's get started so we can get done. What is a canon of construction? Now the fun stuff. You can feel free to read the slides. What I'm basically saying is not going to be on the slides. Just kind of mention certain things about it. They're tools to be used. They're not rules of law. You don't ever want, well, I guess in some instances they are tending to be rules of law, but generally not. The article, the paper that was written, is going to explore the judicial application of canons of construction to mineral deeds with a focus on specific oil and gas producing states. When the paper was written, had no idea that we would be presenting this in North Dakota, and we included North Dakota. So when I get to the North Dakota section, we were going to skim really quick through that part, because I'm sure everybody in this room knows a lot more about North Dakota law than I do. Let's see. Despite the seemingly clear distinctions, courts across the nation continue to struggle with canons and their appropriate applications. Different states have found some canons more persuasive than others. Not every state is going to use the same canons of construction as the other states, which has turned into a little bit of an issue, just because if you're going to cross state lines, what the term mineral means something different here than it's going to be meaning in West Virginia, where I'm from. Still in the introduction. There's some confusion and uncertainty due to the inconsistent use. Confusion, competing policies, and changing circumstances make the courts shy away from using these type of these canons of construction. Although if they would use them, they would help with predictability instead of having to guess the outcome based on some subjective approach. That come into play as far as when you're going into litigation. Start talking about what does this mean or what does that mean. If there was some predictability to it, would be good. The paper itself is broken down into, did I skip one or is this right? The paper itself is broken down into 5 sections once your introduction. Part 2 is going to be how the judiciary uses and should use the canons of construction. Part 3 looks at the canons used most frequently and how they define minerals. Part 4 looks at a small sampling of cases from Colorado, Kentucky, Mississippi, North Dakota, Ohio, Pennsylvania, West Virginia, and Virginia. And please, none of this is intended to be legal advice whatsoever. Part 5 is just going to provide some recommendations. So we'll start looking at those policy considerations. On this slide, one thing that should stand out is that if you look at the left-hand column at the very bottom, one thing that stood out to me was that manipulating process can manipulate the meaning itself. In order to appreciate the role that canons of construction play in judicial decision-making, it is vital to understand the conflicts that shape them. The court should give greater weight to consideration of title stability and predictability when construing the deeds. Stability would be most effectively achieved by establishing reliable precedent to control interpretation in future cases. However, the practical difficulty of applying such precedent to decades-old instruments remains a strong barrier to such objectivity. In the absence of formal rules, one avenue to greater predictability may come from improved consistency when drafting the documents. Probably one of the single most frustrating issues that we deal with, especially in Appalachia, is what is a mineral. The term mineral itself. There's a lot of contention as to what that actually means. Courts today uniformly follow a golden rule of contract interpretation. Court will construe a written instrument to give effect to the clear intent expressed by the parties when they entered into the contract, which, I'm sure most of us realize this, it could have been 5 years ago, 10 years ago, 20 years ago, 100 years ago. So that always creates a little bit of an issue. Litigation to determine the scope and legal effect of a mineral grant or reservation based on generalized descriptions such as all minerals, or it gets even better when you start talking about coal and other minerals, or oil and gas and other minerals, or some substance and other minerals. These type of things have reached the highest courts of most of the states. Another issue is whether these disputes are actually questions of law or questions of fact. If it's going to go, if the judge is going to look at it, it's a question of law, a question of fact, a jury or a judge sitting as a jury. A number of states have held that particular aspects of a mineral grant are decided as a matter of law. Some have decided they're not. It's still all in a great amount of flux. Another issue arises because the original parties to a document are very rarely the ones that are involved in the suit itself. It's going back to when these documents were signed, when the agreements were made. Was it 50 years ago and those people aren't around anymore, or was the interest basically assigned further and further down the chain? One question I did have that I didn't look up: when in North Dakota, is there a severance of minerals, and what was there a time frame when that generally got started? Does anybody know that? When you're looking back in Pennsylvania, West Virginia, you're looking, the late 1800s, early 1900s, where they were severing minerals away from the surface estate. Is it the same time frame in this area? 30s and 40s. So we're still looking at a decent amount of time between when severances have happened. So it's very possible that people are still not, they're not around even now to, be able to talk about the intent of what was, meant in the documents. And the judge, court's going to look to intent. That's what that basically was. Ambiguity and extrinsic evidence. The court can make the determination that no ambiguity exists just from the language of the document. If the court finds ambiguity exists, then they find evidence to prove the interpretations. So you have to find the ambiguity to be able to go further. The realm of judicial decision-making, which deservedly brings the most criticism to the use of canons, is their indifference of basic principles concerning the admissibility of extrinsic evidence at trial. And this in no means is to downplay our judicial system whatsoever. Part 3, as we're going to discuss in the paper anyways, Part 3, many of the canons frequently employed to determine the legal effect of a grant or reservation of minerals requires the court to consider surrounding circumstances to discern the party's intent. In West Virginia, Supreme Court of Appeals, which is our highest court, offered a prime example of this confusion in a particular case called Department of Highways v. Farmer. And in that case, and we'll discuss a little bit when we go into the West Virginia case law, they were discussing about gravel and sand and whether or not that was considered a mineral in an oil and gas conveyance. The court, I feel, accurately summarized West Virginia precedent, which allowed extrinsic evidence only if necessary to construe an instrument the court has found facially ambiguous. Then again, the court went further on, and they considered other things to find this ambiguity. Instead of just looking at the document itself, they were looking at extrinsic evidence. So kind of, they had the right premise, but kind of went a little bit further probably than they should have. However, a court makes that determination, whether by means of extrinsic evidence or not. If it determines that the instrument is ambiguous, it must then decide what evidence may be admitted to resolve the dispute. It is often the case that these original parties have given no thought whatsoever to whether the substance in question should be included in or excluded from the grant or reservation of the minerals. If, back in the 1940s, you sit up here in North Dakota, 40s, 30s, 40s, 50s range, if they were severing away, if in a deed prior to that, back in, say, the 20s, there had been a conveyance and, they conveyed away the property and reserved coal. Is there coal up here? Okay, they reserved the coal, pardon my ignorance, and other minerals. But, the other minerals, they didn't know what those other minerals were. Would it hold that the oil and gas was part of that severance or that reservation? Probably not. Maybe so, depending on the canons that they use. I believe up here you guys have statutes that cover most of that anyway, if I remember correctly. But anyway, it goes back to the intent of the parties. That's where a lot of this is going to come from. What was the intent itself? Okay, when you start talking about canons of construction, the court's going to generally follow a three-step process. They're going to determine the intent of the parties from all the terms of the instrument. If the intention is doubtful, they'll use construction aids to clarify the intent. And if it's still ambiguous, then they're going to use parole evidence beyond that and extrinsic evidence. The full gamut of canons of construction applied across jurisdictions is nearly unquantifiable. We limited a lot of the paper to just a few canons that seem to be the ones that were used most often, at least in the states that we decided to look at. Four corners and harmonization. This is generally where courts begin their analysis, but because there's not usually enough verbiage to determine intent to go on, the additional canons are looked into. This principle is followed throughout the states and is used for interpretation purposes. Generally speaking, the Four Corners Doctrine calls upon the court to ascertain the intent of the parties from all the language of the deed or the document. So they're going to look to the entire document, look at all the provisions of that document, try to figure out the intent. And we're going to talk about several of the canons of construction that are throughout the paper. The plain and ordinary meaning. And let me give, do we have law students that are in the room? 1, 2, 2, 3, 4? Okay, don't go anywhere. I'm going to have a question for you guys in a little while. I figured I'd pick on the smartest group of the bunch, the law students. Okay, we're going to just go through these. It's pretty simple. You don't have to take a lot of notes. No right or wrong answer, so relax. The plain and ordinary meaning basically is what it says it is. It is what it is. The issues that have here, the courts look to members of the relevant public, which can be scary, and decide what they think it means. Basically, here's what it says. I mean, just what is the general public going to think that phrase means out of the document? Contra preferentum, the court will look to whoever drafted the document, generally the industry, a lot of times when you're looking at leases, or the grantor in a deed, and they're going to construe the document against them or in favor of the other party. It's simple, it's justified, because the drafting party to a contract maintain final control generally over that document. If you're looking at a company in the industry that's preparing leases, generally it's the companies that prepare the lease, and they have the land agents that will then go out and go to the landowners or the mineral interest owners and have them convince the mineral interest owners to sign the lease that they have prepared. Generally, we found that it keeps your industry in check. They know that they're going to be held accountable for what's in there anyway, so it's generally worked out pretty well. Adjustum generis, it's probably a better Latin phrase for that, but general words that follow specific words are limited to things of the same kind. Okay. The drawback to applying this consistently should be readily apparent. Despite its textual focus, courts lack any objective standard for guidance in choosing the qualities that the named substance shares, and which of those will be determinative to define the class of minerals conveyed or reserved. Nonetheless, many courts continue to use this canon to support a given deed construction so long as the resulting construction does not break down the plain meaning of the language itself. The community knowledge test is considered a mineral if it was regarded as such by the community in which the instrument was given at the time of the conveyance. So if at the time of the conveyance, or the time the instrument was created, if at that point in time it was, whatever it is, was considered a mineral, then probably it's going to be found that way in the document itself. Okay. And then the surface destruction test. Generally, I found this particular one being used when you're talking about sand and gravel. And it seems to be that the premise behind this is that if you're granting something and you're reserving, say, minerals, they can't interpret minerals to mean more than what was granted. So if you're granting property but you're reserving the coal and other minerals, and you want to go back and get the gravel off of the surface, well, you've effectively taken away everything that you've granted because you're tearing up the surface. So I guess it gets a little more complicated than that, but anyway. Okay, now to our law students. So 1, 2 over here. 3, good. Okay, real simple. If you look at 3 of those tests, the canons of construction that we used, okay? Look at the plain and ordinary meaning, the adjustum generis, and the community knowledge test, those 3, just those 3. And if you take the words coal and other minerals in a document itself, just by looking at those 3, what would you think would be reserved? There's no right or wrong answer, just your own thoughts. This just breaks it up a little bit so I can stop talking. I can have a microphone brought around if that would be more convenient. All right, come on.
In the context of those, everything except for gravel and sand. When I think of just before law school, when I thought of minerals, I thought of oil and gas and things of that nature that are in the ground, and then after going through cases, you see that gravel and things like that are included. So be specific.
Are you from North Dakota?
I'm from Montana.
Okay.
But I've also been to Appalachia.
Oh. So we need to teach you how to talk.
Yes. Yes.
It's pronounced Appalachia.
It's it's Buchanan County. It's not Buchanan.
Actually, I had a very funny discussion about that. I think it was just, and believe it or not, it was in Pennsylvania. which, you know, the Appalachian Mountains go through Pennsylvania. And this person swore up and down it was pronounced, I can't even say it, Appalachia. But
No.
here nor there. Okay, now think about it in the context of back in the time when it would have been severed. So let's say, you know, 50 years ago. You're in Montana. Is that Big Sky Country, Montana?
It is.
That big? Okay, good. All right, so you're in Montana. They have oil and gas production in Montana?
Yes, in the eastern side of the state.
Okay. And about what time frame did they start severing out interest? Do you know?
I don't.
Okay, I don't either.
It's part of the box.
No wrong answer.
Anybody?
We'll
know?
say in the 50s.
Yeah.
Okay. So if you're looking at back, say, 1940, and someone sold coal, is there coal production in Montana?
Yes.
Okay. Do you know when that started?
A long time ago.
Good. All right. So we've got coal production before oil and gas production. So somebody says they're going to reserve coal and other minerals. And now you're looking 1940, so there's no oil and gas production at the time. Okay. Do you think a court would say that oil and gas was part of that? If you're looking at any of those?
Those three canons? No.
Okay.
Just in that context, in that time period, you were looking at coal, and, you know, hard rock type minerals, not liquid gas and oil.
Okay. Good.
I agree.
Oh, she got off too easy. Okay.
The
We're
law
gonna give you-
students concur.
Oh, crap. Where's your teachers? Are there any professors in this room? All right. Very good. Have you been on the trail? Last Christmas, my daughter bought me a book, Pictures of the Appalachian Trail. I'll go to my deathbed saying Appalachia, by the way. Beautiful, beautiful pictures. Well, since they agree, we've got to go on to cases, so sorry. Where are we? State survey? Colorado. Okay, we'll start here because I have a long thing to say. It's not important. Colorado. I told you we're going to get through this quick, folks. This is going to be the fun part because I scribbled a lot of this down this morning while I was still in my room, resting and not here. So bear with me. Colorado seems to use the community knowledge test. There's a case called Farrell v. Sayre. Do we have any Colorado attorneys here? Good. I can say anything I want. Farrell v. Sayre case, it's a good example. Here's the quote. Accepting and reserving all minerals and mineral rights and rights to enter upon the surface of the land and extract the same. Now in this, the question came up is, does that include gravel? You would think it does. I would have thought it does. But they said no, that generally the surface destruction test that we talked about, because basically what you're reserving is in effect taking away the entire grant. If you can go on there as the mineral owner, dig up the entire surface together, the gravel, then the surface owner basically has nothing, which is in effect giving them nothing, which you can't do if you're going to grant them something. There's also a nice case, McCormick v. Union Pacific Resource Company, which basically seems to say that Colorado follows the majority rule, that the reservation of minerals, and minerals in quote, reserves the oil and gas. There's some limiting words in that case about basically if there's ambiguity or demonstrated intent to the contrary. Getting a little bit closer to home, we're in Kentucky now. That's a fun read. I'm just going to go through, there's a case in Kentucky, it was back in 1919, Scott v. Laws, and in that case they talked about, they had a long list of different phrases that Kentucky used, or Kentucky recognized as conveying oil and gas. And I wanted to read those to you because it takes time. All of the mineral rights and coal privileges, also the right to search for all undiscovered minerals. That was held to include oil and gas. All minerals on described tract. So far that makes pretty much a little bit of sense. All the mineral rights and coal privileges. That was held to convey oil and gas. All the coal, saltwater, and minerals. All the coal, minerals, and mining rights. These were all held to convey oil and gas. Here comes the fun part, though. These next two, there was no punctuation whatsoever. Coal mineral rights, no punctuation. That was said to include oil and gas. Coal minerals and mining privileges was said to include oil and gas as well. Too bad the Bakken Shale doesn't go to Kentucky or the Utica. Mississippi. Mississippi looks to several of the canons for guidance. They look to the rule of practical construction, community knowledge, and justum generis. Someday I'll learn how to pronounce that. In Mississippi, because oil and gas has been on the minds of people since 1937, I guess that was around this time when they had their first severance, all transactions after that time frame include oil and gas. Prior to then, they look at a lot of different stuff. North Dakota, everyone knows North Dakota. Okay, see how fast I can read this. North Dakota, the court looks to qualifying circumstances, words or context, custom and usage, statutes, precedents, or common sense. And that was the best part of North Dakota, is they look to common sense. I've not found that in any of the other states. So kudos to North Dakota. Minerals cannot be defined so broadly that it defeats the grant, but effectively reserves all that soil, kind of what we talked about when we were talking about the gravel cases. And then the limiting statutes. Well, they call them limiting statutes. I'm not sure if they're limiting statutes or not, but statutes up here, the court also looks to those. Ohio. They seem to look to the community knowledge and exceptional characteristics. Early cases, the term minerals did not seem to include oil and gas, but as production increased throughout Ohio, now it seems as though oil and gas has become included in the term minerals. So it's kind of a wishy-washy East Coast kind of thing. Pennsylvania, I'm not going to get a lot into Pennsylvania just because I know we have some scholarly Pennsylvania attorneys in the room. There are a couple of fun little cases. I don't know if anyone's heard of the Dunham case. Basically, Pennsylvania is when you have a conveyance or a reservation and it talks about minerals, minerals does not include oil and gas. There is a case now that it was like 2011. It was the Butler case. Created a lot of stir because the thoughts behind it is that it's going to, or it could possibly destroy, I don't know when Dunham was, but it could destroy years of Pennsylvania precedent just because of the way that the court is looking at this case. It's still on appeal. Excuse me, Glenn, do you know if that's?
It's still on appeal. They've had argument before the Pennsylvania Supreme Court.
Okay.
And the Dunham rule goes back to 1885.
Okay, so 1885, it's been the law in Pennsylvania that it does not include oil and gas, but so this Butler case could have a little bit of disruption in Pennsylvania precedent. So that's always fun to keep an eye on. Are we finally to by God, West Virginia? Thank goodness. Okay, West Virginia. Generally, it's going to include, if you give the term minerals, generally it's going to include oil and gas in a reservation. The court tries to place itself in the situation of the parties, which is generally a pretty good idea. Reservations are construed strictly against the grantor. I think that's pretty common. There's one case that I looked at in West Virginia. It's the one we talked about earlier, Department of Highways v. Farmer. And that was the one where the There was the grant, and the guy reserved the, if I'm not mistaken, other coal and other minerals or something along those lines, and then they were arguing. The Department of Highways came in and was going to take sand and gravel for road purposes. The surface owner then received monies. The mineral owner said, no, wait a minute, the gravel is a mineral, and we should receive some of those monies. And basically the court said no, because of what we've talked about the whole time, was that, you know, if you're going to grant something, you've got to grant at least something, not leave it away, destroy the entire grant. Tennessee, the courts have said the terms mineral is ambiguous. Duh. They should look to each case to make the determination as to what is included. So Tennessee is going to basically do a case-by-case analysis for the minerals. Virginia, decisions on what is a mineral in Virginia turn on the language at issue, the surrounding circumstances, and the intent of the grantors. And that flies us through all the states. Recommendations and my conclusions. You can read that on your time. It's time to go, sorry. For some states, ascertaining the intent of the parties is a weightier policy consideration. Those states' determinations are always made on a case-by-case basis to determine what the original parties to the particular contract intended. Such an approach at first blush may appear to be more equitable. However, the search for intent often becomes more about the application of canons of construction. In that situation, who can say that the meaning finally determined to be the party's intent was what those individuals had in mind when executing the deed so many years ago? Since we can't pull them into court, either they're dead or gone or don't have an interest, or don't even care about it anymore. You know, who's to say what that intent was? This approach stands in stark contrast to that taken in other states, which favor an established rule of law for reliability determining mineral ownership. North Dakota, for example, statutorily set the interpretation to be given to the term mineral as used in a conveyance of real estate, although the definition is not applicable to instruments executed prior to the enactment of the statute. I'm sure everybody knows that. Other states have determined that other minerals includes oil and gas. Some states have decided that it does not. However, the predictability afforded to title examiners and property owners, especially for the purpose of securing the capital needed for mineral development, may be deemed to outweigh any detriment to intent. Only through the clarity that we can come by through the canons of construction, by their use, can we hopefully have some security in knowing what actually a mineral is. Oh, dark 30, let's roll. Any questions? I know there are, because I flew through that pretty quick and they cheated and sent me questions. Not from you, though. Sorry. Do you want me to give you the canned questions, or are you good with your?
This one shouldn't be too tough for all the geniuses in the room, but I come from this place far away. Sometimes it's called the land of fruit and nuts. And
is that near the land of milk and honey?
yeah, it is. And so out there we have surface ownership, which extends from the ground to 500 feet down.
Okay.
And I guess maybe I'm under the impression that that's not the case in other jurisdictions around the country.
I can speak slightly intelligently about Appalachia. I'm not so sure about North Dakota. We'll pretty much sell you whatever you want. I mean, if you want there's coal outcroppings of coal that are so close to the surface. I mean, I've seen those reserved in deeds for home use generally. It's not a real thick seam of coal. But, a lot of times someone will sell off, you start off with a 200-acre farm. Someone will sell off the surface or sell off, back in the late 1800s, early 1900s, they were selling what was called the Pittsburgh seam of coal, which is a seam of coal about 900 feet down, about anywhere from 7 to 10 feet thick, probably. So they were selling that off for production and reserving all other minerals. But then there's also smaller seams of coal above that. So yeah, I don't. Generally, at least in Appalachia, whoever owns the surface is going to own anything to the center of the earth that has not already been previously sold off, and depending on what that is, it could be oodles of things. As far as out here, I'm not sure. Out here, is there something in this region that's different? He said there were a lot of brilliant minds in the room. A lot of brilliant, bashful minds. Sorry. No?
I think it's fair to say in the states where Steptoe operates, which is primarily, as Dan indicated, the Appalachian states, it depends in part on the nature of the conveyance. That is, starting with a fee simple estate, if you're conveying the surface away and reserving the mineral, you're getting a different packet of rights than if you're conveying minerals and reserving the surface. And if I understood the reference to the idea that somehow the surface, a conveyance or a reservation of surface goes to a specific depth of 500 feet, I mean, I think it's fair to say in the Appalachian states that there's no corresponding element that would say down to 500 feet. But almost certainly, if what you've gotten is the surface only, you have the ground at least through plow depth, and in all likelihood through what you would consider to be the shallow aquifers. That is, the surface owner certainly has the right to drill for water, and that's associated with the surface right. And it's hard to say exactly where that is, but certainly, in Ohio, West Virginia, Pennsylvania, you'd have to say that includes depths to 100 feet or so. But I don't think that there's any case law in the states that we're talking about that says that surface as a matter of law includes from the top of the earth down to 500 feet.
Yeah, I've never seen anything that has set it out clearly like that. No. Any other questions?
I'll ask one of the ones we let you in on before, but in your experience, what are the best practice concepts that lawyers can utilize when drafting mineral contracts that would lessen the probability of future litigation?
Be very detailed. Because at least what I've seen, that seems to be where a lot of the issues are. If you want the oil and gas, say it. My uncle told me one time I was at a restaurant with him, and he said, "What do you want to drink?" I said, I don't know. He said, "You want chocolate milk?" I said, "Yeah, I want chocolate milk." He goes, "If you want chocolate milk, say you want chocolate milk." But it's not that difficult. If you want it, say it. Put it in there. If you don't, okay. But if you're going to leave everything very ambiguous, then you're going to leave it up to someone else or a court to make that determination as to what it is you may have gotten or may not have gotten. So detail.
I guess I can ask one of these questions too. In your opinion, should there be more or less extrinsic evidence be allowed during mineral disputes than in other contract disputes?
I think that, and I didn't prepare answers for these, as you can tell. I said I got the questions. I didn't do anything with them. I would think if you're looking at leases or a document, I think that the standard's the standard. I think how you get a court to, if there's any judges in here, I'm sorry, if you go to court to understand, what a mineral is, then, we need to be proactive in saying what a mineral is and, making sure that there's publications out there. Or you know, to help out my litigation friends, let's bring some cases. You know, let's make those determinations, let's get it out there. But as far as to add things, and I think there was another question that I did read, was about, I don't remember what it was. Anyway, so, something along those lines, though, but I don't think that we need to, no. In my opinion, I think what's there is fair, and if it's followed, if it's done the way it's supposed to be done, and not in reverse order or backwards, you know, trying to make these interpretations. I think it's crucial that it's done properly. Yes. Thank you very much. Appreciate your time.